Hello everyone and welcome to Uncivil Law. And for today's video, we're doing a response to a recent article that was written. This article was written in response to Justice Gorsuch's recent opinion in the gays in the workplace and homosexuals in the workplace and transgenders in the workplace cases that just came down, in which he held that the employment law forbids discrimination on the basis of sex for those reasons. And someone wrote an article saying that Justice Gorsuch was only half a textualist. And so I thought it might be an interesting read because I thought that Justice Gorsuch, what he wrote, made a lot of sense in sort of a textualist argument. But this is arguments coming from the libertarian right, and they say, well, he's not really good textualist. So I thought it might be interesting to read their article and see what I do or do not agree with and see if they can change my mind. So we're going to read this and see if they change my mind. See, do I think that Justice Gorsuch got it right? Or do I think that maybe he got it wrong and he's not that great a textualist? Let's read it and find out. So this article is entitled Justice Gorsuch's Halfway Textualism Surprises and Disappoints in Title VII Cases, written by people I describe on the libertarian right, Justice Blackman and Randy Barnett. So we're going to read this and see what they have to say. Title VII of the Civil Rights Act of 1964 made it unlawful for employers to discriminate against employees because of sex. Did that landmark statute also prohibit discrimination against employees because of orientation or identity? In Bostock versus Clayton, the Supreme Court answered yes by 6-3. Justice Neil Gorsuch wrote the opinion, which was joined by John Roberts and the four progressives. But we are both surprised and disappointed by how Justice Gorsuch's majority decision. And after some reflection, we think we know where he got it wrong. Okay. Justice Gorsuch's analysis did not begin with first principles. Rather, he simply assumed that decades of case law accurately interpret Title VII. Well, I don't know what Justice Gorsuch thinks about precedent at large, but he doesn't strike me as a person who thinks precedent is all irrelevant. So if he has to do a new question, he will do a new question. But when it comes to precedent, I think he values it. So the idea that he factored in precedent as part of his decision doesn't strike me as weird. And also doesn't strike me as incompatible with first principles, but perhaps we'll get back to that idea too. Indeed, he treats decades of precedent as part of the law's ordinary meaning in 1964. Moreover, Justice Gorsuch fails to recognize the relationship between two essential phrases in Title VII, discriminate against and because of. These terms cannot be considered in splendid isolation. When combined, they refer to discrimination based on bias or prejudice. In short, Justice Gorsuch built an elaborate textual framework on a shaky foundation. Regrettably, this halfway textualism led Justice Gorsuch astray. Through the Civil Rights Act of 1964, Congress took a momentous step to eradicate prejudice and bias in the workplace. Title VII of the landmark law made it unlawful for employers to, quote, discriminate against any individual with respect to his compensation, terms, conditions, or privileges of employment because of such individuals' race, color, religion, sex, or national origin, unquote. Despite how some critics characterized Bostock, all 9 justices agreed, at least for the purposes of this case, that sex referred to biological distinctions between male and female. So yes, it means that and nothing more. The meaning of the word sex did not evolve, and the majority did not update or rewrite the statute. What fractured the court was a critical relationship between two terms, discriminate and because of. So this article author suggests that the problem is a relationship between two phrases, whether or not they should be understood separately or whether or not they should be considered as one thing. And whether or not the legal outcome depends on which of those you do. So the article authors are suggesting that if you read them contemporaneously as one phrase, you would come up with a different legal result than if you read them separately. Okay, I'm certainly amenable to that suggestion. It's not immediately obvious to me why, but I'm sure the article authors will get into that. So then what I'd have to decide I have to decide essentially two things here. For me, I have to decide if reading the two phrases separately versus together, whether that suggests a different legal outcome. So does it matter? And if it matters, then which is the better reading? So I have to make two decisions. So first we have to get to does it matter? And we haven't gone that far, so let's figure it out. Let's start with the first term. How is the phrase discriminated against understood in 1964? Fair enough. Justice Gorsuch cites the definition of discriminate from a 1954 dictionary, which is reasonable. It's a reasonable place to look. To make a difference in treatment or favor as compared with others, which is exactly what you think discriminate would mean, to treat differently. That's to discriminate. But that's not the entire phrase used in the statute. The Title VII uses the phrase discriminate against, and the word against modifies the meaning. Okay, fair enough. I buy that. So yeah, to discriminate by its own terms suggests either in favor of or against. So discriminate is a little bit broader. So the statute narrows it. So we could prohibit discrimination both in favor and against, but the statute uses the word against. So we're only considering the word discriminate in one aspect of it. Now, query why that matters, because to discriminate against is implicitly to discriminate for, because you can't discriminate against somebody without discriminating for someone else implicitly. So you can't give someone an advantage without implicitly giving people disadvantage, and you can't give someone disadvantage without implicitly giving someone advantage. So I half agree with this idea that we're only looking to discrimination against, but it's a little unclear how you can discriminate in favor without also discriminating against. So let's read on. To define discriminate against, Justice Gorsuch relies on a 2006 decision by Breyer, which states that no one doubts the term discriminate against refers to distinctions or differences in treatment that injured a protected individual. That makes sense. However, Justice Breyer was interpreting a different provision of Title VII that governed retaliation. Fair enough, and different provisions of law can have different meanings or not. So yes, that might be a distinction. Moreover, Justice Breyer made no effort to understand how discriminate against was understood in 1964. Instead, he relied on a 1989 decision by William Brennan. But this decision did not turn on the meaning of discriminate against. Rather, Justice Brennan considered the phrase because of. Justice Gorsuch's research trail slams into a brick wall. Yet despite the incomplete analysis, Justice Gorsuch concluded the phrase to discriminate against a person then would seem to me treating an individual worse than others who were similarly situated. Which, okay, that makes sense. He read as much case law as there was to be read, and then he ran into a wall and he interpreted it beyond that. So he's giving faith to the precedent where it exists, and where it doesn't, he's giving a interpretation because he has to, because he's a judge. And he's interpreting it to mean discriminate against, means to prejudice. And I'm like, that seems like a perfectly plausible reading to me. Okay. Justice Gorsuch committed errors of both source and time. He determined the ordinary meaning of 1964 statute by relying on case law from decades later. Yeah, but it is precedential. So, and it may or may not read on the same section, but it's something. We're reading apparently the same statute, and we're using similar phraseology in the same statute. So one decision that's reading on a phrase that's similar is reasonable authority to interpret a different section. Of course, we could do something different, but it's at least suggestive, and we don't have anything better to work from. So it's a reasonable thing to read. In 1964, there was another sense of discriminate against that Justice Gorsuch did not consider. Okay, so maybe he didn't consider something we should have. Professor James Phillips conducted a thorough study of how the phrase discriminate against was used in the 50s and 60s. That phrase did not refer merely to differential treatment. Rather, discriminate against refers to differential treatment based on some trait that is motivated by prejudice or biased ideas or attitude. Fair enough. The Webster Dictionary from 1960 accurately captured this sense, to make distinctions in treatment to show partiality in favor of, or prejudice against. Okay. And Funk and Wagnall's Dictionary from 1963 provides a similar definition, to act towards something or something with partiality or prejudice, to discriminate against a minority. So far, so good. Recently, a biopic was made about the life of RBG herself. Its title, On the Basis of Sex, was an homage to the widespread understanding of what it meant to discriminate against women on the basis of sex. Sure. In 1973, Ginsburg, then an ACLU attorney, argued Frontero versus Richardson. At the time, the Air Force granted certain benefits to a male officer's wife, but denied those benefits to a female officer's husband. Ginsburg contended the law was premised on the stereotype. During argument, she told the all-male court that the government assumes that all women are preoccupied with women and children, or home and children. Such prejudice, she explained, helped keep a woman in her place, a place inferior to that of a man. That bias and prejudice formed the basis of sex discrimination. Seems like a cogent argument. Had Justice Gorsuch relied on the ordinary meaning of discriminate against in 1964, he would have recognized that bias or prejudice had to play some role in differential treatment. Okay, fair enough. But to bias is, okay, I'm on board with you so far. I'm not seeing how it leads to the conclusion, though. So yes, bias or prejudice. To prejudice is to prejudge, to make assumptions or treat something based on something else. And bias is to treat one versus differently. That's a bias. To give a bump or a detriment is a bias. It's loading the dice. That's bias. And a prejudice is prejudge. So okay, I'm on board with these definitions. I just don't see how it reaches your conclusion yet. Let's read on. It wasn't enough to merely treat people differentially because of sex. Fair. But I don't get it. Because if you're treating people differentially or differently, how is that not bias or prejudice? So, yeah, there might be a point here, but I'm not quite getting it. Regrettably, Justice Gorsuch cherry-picked definitions. I'm not sure how it matters, though. And he did not acknowledge contrary evidence. I'm not sure how it matters. Moreover, Justice Gorsuch treated judicial decisions from decades after enactment as part of statutory meaning. I'm not really sure that's what he was doing. It doesn't strike me that he was using those as providing a definition of what the ordinary meaning was. He was using it as precedential authority. And yes, they were interpreting different sections of different laws. So sure, we could split the baby, right? Because words can mean different things in different places, even in the same statute. So yes, we could split the baby. We could treat this phrase in one part of the same statute as different than the same phrase in a different part of the different statute. They can mean different things in different places. But it's at least persuasive, it's at least relevant. If we treat this language in one place in the same statute, it's at least suggestive of what it might mean in a different place. So we could do something different, but you haven't shown me why we should do something different. So yes, this didn't show the original meaning, but it's precedential. And even if Breyer got it wrong, you haven't shown me why Breyer got it wrong. And you're not showing me why it means something different in 1964. So you're making a lot of points here, but I'm not seeing how the points add up to the end conclusion yet. I'm not seeing the chain of argument. They're like little breadcrumbs left in the dirt. And I'm not seeing the pattern yet. The second component of Title VII is because of. How was because of understood in 1964? To define this term, Justice Gorsuch relies on a 2013 decision by Kennedy. Once again, however, is interpreting a different provision that concerned retaliation. My same critique. And for all the people who say, why are you so repetitive? It's because I'm reading things that in themselves are repetitive. So you've made the same point, and I'm going to give the same rebuttal. Yes, Justice Kennedy was interpreting a different provision of the same law or a different law, whatever, but he's interpreting a different provision. But it's similar language. So sure, it could mean something different here. I have no problem with that. It could mean something different in the same statute past the same time. I'm totally on board. But you're not showing me why it means something different. And you're not showing why Justice Kennedy got it wrong as to this other section. And assuming he got it wrong, why that precedential value doesn't matter, and so forth and so on. So there's a lot of little pieces left in the dirt, but you're not making the argument in a way that connects the flow. So I'm okay, that's interesting stuff, but I'm not seeing the pattern that these dots are supposed to be reaching. And in turn, Justice Kennedy's decision relied on a 2009 decision by Justice Thomas interpreting the Age Discrimination and Employment Act, yet another different statute. Yeah, same argument, same rebuttal. Yes, it's different. Yes, it could mean something different, but why? Why did Justice Thomas get it wrong? And if he didn't, why shouldn't it mean the same thing? And if he did, blah. It's you're making points, but they're not connecting. Justice Thomas' decision relied on Webster's Third International Dictionary from 1966, which defined because of as by reason or on account. By this route, in Bostock, Justice Gorsuch views Webster's Third Dictionary meaning as the ordinary meaning of because of, which seems reasonable, plausible. I'm not getting it. Yet Justice Gorsuch then pivots. He abandons the ordinary meaning, does he? In favor of a specialized technical legal meaning, what lawyers refer to as a term of art, not found in Webster's Third. Does he, though? I'm not feeling like he abandoned a ordinary meaning in favor of a technical meaning, did he? He writes that the language of the law, because of test, incorporates a simple and traditional set of but-for causation. Okay. Gorsuch's quick retreat from ordinary meaning is perplexing. Assuming that he did that, and I understand why you say that he did, you're not, at least to my mind, showing me why it would come out differently. So he's saying, well, because of has a technical meaning as a but-for causation. So it's a legal term rather than an ordinary common understanding term. Okay, I can get behind you, but you're not illustrating why the legal meaning would contradict the ordinary meaning. I am at this point reminded of similar discussions I've had when it comes to Georgia state law on other issues and words that appear in statutes. And like, yes, this language might have an ordinary meaning and it might have a legal meaning. And perhaps I'm wrong to give it a legal meaning, but you're not demonstrating to me why the legal meaning is different from the ordinary meaning or how it would come out differently. So yeah, I can see like why you might be saying that this might have a different, it could mean something different legally as opposed to common meaning, but you're not really connecting the dots of why those things are different. You know, why is the ordinary meaning different than the legal meaning in either Georgia law or now? Not sure. Let's press on. Either the term has an ordinary meaning or it has a specialized meaning. It can't have it both ways. Well, it can kind of have it both ways if the specialized meaning is the ordinary meaning. If based on is a legal meaning, but it just means the same thing as the ordinary meaning, then there's no, it's a distinction without a difference. So sure, it's a legal term instead of an ordinary meaning, but what difference does it make? I don't know. Indeed, the choice dictates the outcome of the entire textualist analysis. You're not really, to my mind, making that point clear. You're not really sufficiently illustrating why, if I gave it the ordinary meaning versus the legal meaning, why my outcome would come out different. So, okay, Justice Gorsuch is applying a legal meaning other than an ordinary meaning. First of all, why is that error? And second of all, if it is error, why does the ordinary meaning counsel a different result? I don't know, because the dictionary definitions of based on seem to be suggestive of the same things the legal definition. There might be some distinction there, but I'm not seeing why it's a distinction with a difference in this case. With that legal meaning, Justice Gorsuch explained that the but-for test directs us to change one thing at a time and see if the outcome changes, which is how you do a but-for test, sure. And also presumably how you do a based-on test, because if you changed one thing at a time, so even applying the ordinary meaning of based on, if you change it and it would no longer be true, then it wasn't based on that thing. So I'm not seeing how the legal meaning is different from the normal meaning, particularly in a way that causes a different result. I'm not seeing it. Would an employee still be fired if she was male instead of female? For Gorsuch, if employee's sex made a difference, we found a but-for cause, or a based-on cause, legal or ordinary meaning. Justice Gorsuch offered a simple to understand example. An employer hires a gay man and a straight woman. Both employers are attracted to men. Yeah, or marry men. The employer then files the male employer because he's attracted to men, but retains the female employee who's attracted to men, or marries the man. Right. Yes, that example makes sense, and it seems like it's based on, in either sense of the word. Gorsuch reasons the employer intentionally singles out an employee fire in part based on sex, and the employee's sex is a but-for cause of discharge. Yeah, it seems like it. Or a based on cause of discharge. So take your pick, legal meaning or ordinary meaning, either way. He adds that sex is necessarily a but-for, or a based on cause when employer discriminates in this way. This is hypothetical. It's not necessary to show the employer was homophobic. Right. If merely the fact served in an agreement is sufficient, correct, because it would have been based on that. So either sense of the word, I'm not seeing the difference. This example works well enough as a logic game. Yes, it does. It reminds me very much of logic games. We all know these very well from our LSATs. Indeed, Justice Kagan, although I don't think they're doing logic games on the LSAT anymore, which is sad, but those of us who are old enough remember them for LSATs. Anyways, indeed, Justice Kagan teased out these sort of hypotheticals during oral argument, and we can see how airtight reasoning may have appealed to Justice Gorsuch's meticulous sensibilities. Sure. Alas, the premise underlying the logic was doubly flawed. First, the analysis relies on precedent that does not take this text seriously. I hate to use the word conclusory, but it's conclusory. Now, maybe you think you made your point. Maybe you think you made your argument, and I'm desperately trying. I really am, because I respect these authors. I really respect these authors. I think they're very smart, intelligent people. I respect them very much. And there are people on the right that I respect. So I'm trying very hard. I'm trying very hard to steelman these arguments. I really, really am. Because if I'm wrong, I'd like to be less stupid. I'd very much like to be less stupid. So if I'm wrong, I'd like to understand why I'm wrong so that I can come into the light. So I'm desperately trying to interpret this in as good faith as I possibly know how. I'm trying to do this at the very top of my intelligence. And it's quite possible these people are just smarter than me, and I'm not able to do it. So maybe my intelligence isn't good enough. But I'm trying, man. And I'm just not seeing it. I really wish I could. I really wish I could see it. And I wish I could see it. And then I could be like, oh, I disagree with you. Either I could say, oh, I agree with you because of this, or I disagree with you because of this. I wish I could see it, because then I could respond to it intelligently. But I'm not seeing it. I'm just not seeing the argument. And it's very frustrating to me, because I know how smart these guys are. And I know that they have a good argument. And I know they think they're making it. And I hate to use the word like conclusory, because it just is so insulting. But to me, it's just conclusory, because it's just, you're getting to the conclusion without making the argument, as far as I can tell. And it's just very frustrating to me, because I don't want to insult these people, but I want to be honest too. And this is just, it's really taxing me. So you're saying that they didn't take the text seriously, but why? Why didn't they take the text seriously? I'm not seeing it. Secondly, and most importantly, it's a mistake to consider because of sex in splendid isolation. The full construct is discrimination against employee because of sex. The halfway nature is what led him astray. I wish I understood. I can only assume at this point that I don't understand the argument. I can only assume at this point that I just don't get it. So I'm going to put this on me. I'm just not intelligent enough to understand the argument, because I'm not getting it. I'm not understanding why the precedent was wrong. I'm not understanding why they didn't take the text seriously. I'm not understanding why those cases shouldn't be read on this. I'm not understanding why this phrase should be read differently. I'm not understanding how these two component phrases read separately would counsel a different legal result than them being read in the same breath. So I'm just not getting it. I wish I was even disagreeing with it. But I don't know that I'm disagreeing with it. I just feel like I'm not smart enough. I'm not smart enough to understand the argument. I wish I was smart enough to understand the argument so that I could say, oh, I agree with you. You've convinced me. Or I disagree with you. This is where you got it wrong. But I feel like I'm just not getting it. I feel like I'm not smart enough to play on this field. And it's frustrating, because I'm trying desperately to understand it, and I just don't get it. I just don't see it. Title VII cannot be dissected like a frog in freshman biology. I have no idea what this analogy is doing. I'm not sure why it can't. I'm also, the analogy doesn't even make sense. Like, if I were dissecting a frog in freshman biology, although I did it in middle school, not freshman biology, so I did it when I was in like 7th or 8th grade, but never mind. But if I were doing this, like, yes, if I were looking at each organ individually, I might reach conclusions that might not be true as to the whole. So sure, if I looked at like the heart and the liver differently, then like I might reach different conclusions than if I considered the heart and liver as part of a holistic system. So yes, having dissected it and looked at it as individual components, I might reach the wrong results. But I'm not sure why I've reached the wrong results in this analogy. I'm not sure why, having dissected the frog of the seventh of the seventh title of the law, why, having dissected and looked at the heart and lung components, as it were, or to put it in the legal language, the based on and discrimination, or whatever the language is. Like, so having looked at the components separately, I'm not sure why I'm reaching the wrong conclusions. Or if I looked at them holistically, why I'd reach a different conclusion. I'm not getting it. It's frustrating to me. During oral arguments in October, Justice Gorsuch suggested the case is really close on textual evidence. Okay. Something apparently changed between October and June when he concluded the law's ordinary meaning was unambiguous. Okay. So he thought about it some more and he changed his mind. Okay. but the meaning only seemed ambiguous because it was premised on a faulty foundation, moving from the ordinary phrase of discriminate because of sex to a technical meaning of because of. I really wish I could see why treating it. I wish I could see the difference in the technical meaning versus the legal meaning. And I wish I could see why it matters. And, again, like, yeah, just as Gorsuch says, oh, it has a technical meaning. The technical meaning is is a but-for causation. So sure, the phrase but-for causation is a legal concept. It's a well-worn legal concept. And so just as Gorsuch says, well, based on is the equivalent of but-for causation, which is a legal concept. And so the article authors were saying, well, you've transformed an ordinary meaning into a legal meaning, but I can't agree because, like, okay, fine. Let's ignore but-for causation. Let's just completely ignore that for a moment and just treat it as the ordinary, common, normal meaning. So we'll ignore a phrase like but-for causation because that's a legal concept, and we'll just refer to based on. So we'll just use it in the pure words it's used. So if we do something based on something, then we're using it as a basis. It is a foundational reason for us doing things. And if we changed it, it would no longer be the basis for it. So yes, if we use the ordinary meaning, it would just be the same thing as the legal meaning. So yeah, we're just back. So I just basically redefined but for without using that language. So yes, using the ordinary meaning just gave it the same exact meaning as the legal meaning without using the legal words. Because what else would based on mean? Based on my interest, I've read this article. Without this article, I wouldn't have read it. So yes, it was based on me reviewing it. So yes, based on this article, I'm reviewing and critiquing it because it exists. If the article didn't exist or it said different things, I'd be giving a different review. So my review is based on this article. So I don't have to use legal words like but for, but it just is the same thing. I'm not seeing it. I'm missing it. In the wake of Bostock, some political conservatives have started to question the meaning of textualism itself. And some of those conservatives are bad conservatives as far as I'm concerned. Because some of those conservatives who are questioning this are questioning because they don't like the outcome. And that's bad legal conservatism. That's bad legal conservatives, and it goes to show the difference between a legal conservative and a political conservative, and why they're not the same thing. A political conservative looks at the text and gives its original meaning as it was understood at the time. So it's originalism. That's original textualism. So sure, there are some conservatives who are both conservative legally and conservative politically, and there are some conservatives who may not like this from a policy outcome. They may not like the policy that the law reflects. I totally respect that. But if they're saying, well, we should abandon textualism so that we get our preferred policy outcome when it comes to a legal outcome, they're being bad conservatives as far as I'm concerned. They want to change the jurisprudence philosophy because the jurisprudence philosophy did not give them their preferred policy result. So we want to abandon textualism because we didn't get our preferred policy result. So therefore, we have to abandon our legal principles because our legal principles, which up to this point we thought were super wonderful, are no longer giving us our preferred policy outcome. So let's abandon our legal principles so we get to our policy outcome. That's being a bad conservative. That's being a bad conservative. And I have no respect for those people who are abandoning this because they think because it's a bad policy result. If they think it's a bad legal result, I'm all about that. I want to understand why it's a bad legal result. I desperately, desperately do. So if you genuinely think it's a bad legal result, if you think it's bad textualism, if you think it's bad originalism, I'm totally on board for that. That's why I'm reading this article, because I desperately want to understand why it's a bad legal outcome. But if you're of the kind of conservative who says, well, I'm going to abandon textualism because it didn't give me my preferred policy result, my answer to you is screw you. Screw you. You don't get to have it both ways. No, we don't get to do that. No, laws mean what they meant at the time and nothing more. So yes, it means exactly what it meant in 1964 and nothing more. And you didn't get your preferred policy result. Here's my world's smallest violin playing for you. I don't care. I don't care because I am actually committed to being a conservative legal scholar. I want to be a conservative legal scholar. I'm committed to it. I believe in it. I believe in it with the depths of my heart. I believe in originalism. I believe in original meaning. I believe in original text. And if someone can show me why, using originalism, this is the wrong result, I'm all about it. Please tell me why I'm wrong. legally. But don't tell me I'm wrong as a matter of policy, because I just don't give a damn. I don't give a damn, you know? So I have all the respect for the authors in this world. I wish I understood the point you're trying to make, but I just can't see it, I guess. I don't know, man. It has to be there. It has to be there, because these guys are smart. These guys are brilliant. These guys can school me. And so I'm like, they must be saying something, and I'm just not seeing it. It's so frustrating to me. I was like, I want us to be able to see it. We understand the visceral reaction to the surprising decision. I don't. The visceral reaction people can go screw themselves as far as I'm concerned. But we think the criticism is overstated. Textualism provides the strongest basis to criticize Justice Gorsuch's majority decision. I wish it did, because I'm not seeing it. In dissent, Justice Alito charged that Justice Gorsuch's opinion sails under a textualist flag, but it's more like a pirate ship. Justice Alito's metaphor is half right. He flew the textualist flap at half-mast. And then we'll talk a little bit about our authors here. Randy E. Barnett is the karmic water professor of legal theory at Georgetown University Law Center. Pretty smart guy. Justice Josh Blackman is a constitutional law professor at Southern Texas College of Law, Houston. Pretty smart guy. They authored Introduction to Constitutional Law, 100 Cases Everyone Should Know. So that is the end of our coverage of the case of Justice Gorsuch's halfway textualism surprises and disappoints in the Title VII cases by what I would characterize as right-leaning libertarian authors, Josh Blackman and Randy Barnett, who I have all the respect for in the world. And I wish to death that I was smart enough to understand their point. I really do. Because I'm desperately trying to crawl at it. I'm desperately trying to understand it. I just don't get it. And it must be me. I must be missing the point, because these guys are brilliant. They're brilliant. I have every respect in the world for them, and it must be that I'm the one not getting it. So I mean, I just don't understand why. I don't understand why based on means something different, given an ordinary meaning versus legal meaning. I understand that Justice Gorsuch said it has this legal meaning, but I don't understand the distinction. I don't understand why, like, okay, fine, Justice Gorsuch got it wrong by saying it was but for. He made a mistake by using that legal language. He shouldn't have done that. He should have given us ordinary meaning. Okay, fine, great. I'm totally on board for that. But I don't understand why then, having done that, why I would reach a different result. Because when you do something based on something, that's what it is. And I don't understand something. And I don't understand why, having dissected the frog and looked at the two components separately, I reached a different result, and I would have reached a different result had I looked at it holistically. I don't get it. I'd like to get it, and I don't get it. So I don't know if either Josh Blackman or Randy Barnett is out there. Maybe I'll reach out to them and see if they want to live stream with me. And maybe they can explain it to me in smaller to easier to understand words or something. So because I'm just not getting it. But that's the end of the coverage of this article. Thank you so much for being part of the Uncivil Law family. I appreciate your continued support. If you haven't already done so, please subscribe to this channel, and you can also support us financially by clicking the applaud button below. Thank you so much for your contributions to our channel. It helps our work grow. Until later, cheers and goodbye.